feel free to turn your video on if you want to. It's up to your comfort level. Let me just see here. So we still have a few people joining, but I'll just give an introduction about myself. So my name is Theresa Marion. Marion is my last name. I was born in Winnipeg, where I went to Marion School. There's Marion Street, Marion Bridge, Marion Hotel. When I came to the West Coast, Marion is not recognized as a family name. So quite often when they see Theresa Marion, people call me Marion as if that's my first name. So just thought I'd clear that up a little bit. I started working in with, I guess at the time it was Aboriginal Affairs and Northern Development back in 2006. And I've been working in lands for that entire time. And I was originally working in what's called now lands operations. So I was doing Indian land registry registrations, where I learned a lot about the various aspects of lands, from registering documents from the various units within ISC. And I've been working on additions to reserves since about 2014. And there's only one other person on the team who's been working on ATRs longer than I have, and that's my manager, Kuldeep Gill. But we have quite a good team working on additions to reserve, and they are becoming more and more well-known and popular. So First Nations are doing more and more applications to add lands to reserve, which means, you know, there's triage, and we have to sort of do the best we can within our capacity to get all the work done. So it looks like we have, when I looked yesterday, there were 17 people registered, and we have so far 34 people in attendance. So I think I'll get started, because this is the kind of thing where in the past I've given like a full day workshop. And so this is being condensed into 75 minutes. And so not quite going at light speed, but I'll be going fairly quickly through the different components of an addition to reserve. I would ask if you have a question that you please put it in the chat so that it doesn't interrupt the flow, and I will be looking at the chat to answer any questions as I find a place within my presentation. So there we go. So can everybody see the PowerPoint here? I'll assume.
Yep, I see it.
There's a thumbs up. Okay, good, thank you. So again, my name is Theresa, and so I'm a senior socioeconomic program officer. That just means I'm a lands officer that works on additions to reserve. And I work out of the Vancouver office, although even before the pandemic, I've been working from home. So this is not anything new for me. So this is just to give you an idea of what I'm going to cover today, so that you know, you have an expectation of where we're going and when we're going to be done. So 6 sections. What is an addition to reserve? The different categories of addition to reserve, types of land tenure that you can have that you're adding to reserve. Number 4 is like the meat and potatoes, major areas and issues that need to be addressed. Like that's the part that you need to really keep in mind when you're choosing land, or when you're looking at how long is an ATR going to take. That seems to be the most common question. The 4 phases of an ATR submission, from the application that you send in to the minister approving the ministerial order to add the lands to reserve, and then other considerations and additional questions. Okay, just wondering where I'll see the chat. So when I'm presenting, I'm having trouble seeing the chat. So I hope if you have anything, Pat can help me with that. So what is an addition to reserve? So it's adding to existing reserve land of a First Nation. So the existing reserve, or that creates a new reserve. So we call it the addition to reserve and reserve creation process. So land can be added so adjacent to an existing reserve, what we call contiguous, meaning it's touching an existing reserve, or non-contiguous, meaning it's separated by a piece of land. So if you have, Indian Reserve number 1, you can add land to that reserve and it does not have to touch the reserve for it to be added to that existing reserve. And that's fairly new. It used to be if you want to add to an existing reserve, it had to touch the reserve. We leave it up to the discretion of the First Nation what they want to do. Do they want to create a new reserve? Do they want it to be part of an existing reserve? The contiguity and all that sort of thing. So we can advise you on what might be the easiest to manage, but at the end of the day, we leave it to the First Nation to make that decision. And an addition to reserve can be added in rural or urban settings. And we're finding more and more First Nations are adding lands to reserve that are within a municipality, like a city, town, or village. And in order to do that, there obviously should generally be a good relationship with the municipality, because you'll usually have to be negotiating service agreements and things of that nature with them. So any questions about what is an addition to reserve? I think that's it's adding lands to reserve. So the categories of an ATR, I don't want to say these are arbitrary. For the most part, under the previous Conservative government, the only lands that were ever added to reserve were legal obligations. Now it's not necessarily the case. So the 3 categories: legal obligation, and that's where there's an agreement with the Government of Canada and the First Nation that contemplates reserve creation. And for the most part, these are usually settlement agreements. So if your First Nation had land that was taken away, or a reserve that was created but then somehow forgotten, and there's a settlement agreement where there's usually money and then an agreement that say, and you can add up to X number of acres to make up for the land that was lost, that would fall under the legal obligation category. Community addition is basically the catch-all for everything else. There's a variety of different subcategories within that. And various regions do it differently, but a community addition means you want to add it for your own reasons, whether it's economic development, whether it's housing, whether it's to restore the integrity of a part of your reserve, whether it's to preserve nature, or whether it's for archaeological reasons. It could be, anything that's important to the First Nation, then that's a community addition. Another community addition is, say, and we find this happens occasionally, sometimes there's a municipality that has land that they want to dispose of, or sometimes maybe not so much the province. They'll say to a First Nation, we will give you this land as an act of reconciliation. And there might be an agreement. It's not a legal obligation because that's not an agreement with Canada. That would fall under the community addition category. The third category is tribunal, and that's when they get compensation from the specific claims tribunal. So it's a very specific, and we've never had that in BC, and I think it's fairly rare in the rest of Canada, but they've created that as a separate category. So are there any questions about categories for anybody? I know I'm moving kind of fast, but just to give you an idea, when it comes to you doing your application, you can talk to one of our staff and we will help you through the application. Now, I'm just going to take a moment. I see that we have, I don't know, I can't see the number of people that we have here. we have 46 people on this call, on this workshop. So I just want to run a little poll because I find it helpful for me in terms of how I target what I focus on to find out about who people are that are attending this workshop. So this is, and I don't know if some of you have the Whova app where they've asked you who you are, that kind of thing. If you can just take a moment to just to indicate who you are, who you're representing, it just gives me a sense of the audience that I'm speaking to today. Because I know there's government employees, business and whatnot, so just give you a few more seconds because there's 44 people and we've got about 33 who have responded. So a question that came up is, can the specific claims speed up the process? In a nutshell, nothing speeds up the process, maybe money. Money in the sense that what slows down the process is things like environmental issues that need to be remediated or third-party interests that have to be negotiated. If, you know, and I'll be covering that a little bit later, but the fact that it's a spec claim or, you know, whatever doesn't necessarily speed up the process any more than if it's a community edition. Okay, well, I think, and we've got 37 people, so if everybody's had a chance to vote, I'll just end the polling. And so it looks as though people who work with First Nations land managers or other employees make up the bulk of people who are attending. There's some government employees, Indigenous business, and then one chief or councillor and one First Nation member. So that's good. And now the second poll, which will help me, is just if you're representing your First Nation, as opposed to like government employees, can you let me know whether or not you have an active ATR, like you're currently working with someone, if you own land that you're considering for an addition to reserve, if you have lands that you don't own yet, but you're considering for an addition to reserve, or you don't have any lands targeted, but you're just gathering information so you can look at that for the future, because that's helpful as well. And for those who do have active reserve additions to reserve, I can answer general questions. If you have specific questions, I can look up who your officer is and make sure that you're in touch with them to get the specifics on your addition to reserve. And if you have multiple ATRs on the go, that's amazing, because it's although you want to make sure that they're active in the sense that you are working with an officer, because sometimes there's what a First Nation might think is active, but then when we look on our list of active ATRs, they're not there. So again, if you, this workshop goes till 10:15. So if you have questions about your active ATRs, you can stay after 10:15. I'll stay till 10:30. And I've got my list open so I can look up your First Nation and tell you what we have that's active, so that if there's something that you think is active, then we can stay in touch about that. Okay, so so here we have 10 people who have an active addition to reserve, 5 that already own lands that are being considered, 3 that they've identified lands for consideration, and 8 people with gathering information, and 2 with other. So thank you very much for that. That's helpful. So I will go back to the PowerPoint. So there was a question, can Indian Affairs assist on applying for road access to a small reserve to develop better access? That would either be community infrastructure that might be able to help you with that, or maybe land operations like one of the lands officers. So if you want to give me your contact information, and I'll give you my email address at the end. It's just my first name, last name at canada.ca. You can email me and I can put you in touch with whoever can help you with that. So for those of you considering purchasing land or acquiring land, this just gives you an idea of the types of land tenure that, that you can look at when you're adding lands to reserve. So provincial crown land. So sometimes you might identify provincial crown land in your area. You need to engage with the province about the land before you even consider applying for an addition to reserve, because you have to know that the province is agrees with contemplating transferring the land to you. The province by law cannot transfer land except at full market value. But if you may negotiate with MER or some other department if there's something else going on that they may pay for some of that cost, but just be aware that the value of the land needs to be appraised before the land can be transferred. Now, federal crown land, like sometimes if the federal crown is disposing of land, that's Public Works that does that. So Public Works has their own duty to consult. So before the Public Works can consider disposing of crown land, even to a First Nation, they have to consult with First Nations groups in the area to ensure that that it doesn't infringe on their rights and title. But again, once it's been determined that you can add those lands to reserve, then it would be an application and we would look into that. Then there's fee simple land. So that's where title has been raised, and quite often this is land that would be held by the band corporation, or sometimes there's a trust agreement. And rarely we have an agreement of purchase and sale with a third party that owns the land that's contingent on the land being added to reserve. But that's a really tricky one because the ATR process is very, I don't want to say long and complex, but it's kind of long. It can take like a good 2 years. And is a seller going to want to wait that long with a deposit waiting for you to get the lands added to reserve? So it's just something to consider. And just going back to the question that somebody had asked about roads, roads can be very complex. And in BC, on reserve, roads on reserve and roads outside of reserve, there's often uncertainty about the status of roads. So there's a lot of research that needs to be done if you're considering adding land that has roads, or you might be adding those roads to reserve, because I'm working on an addition to reserve, adding a closed railway, and the province went and built a road on top of the railway right of way without regularizing it. So things can get very complicated very fast when you're looking at roads. And then just as a technical piece, before the submission is sent to the minister for approval, it's at that point that the land gets transferred to Canada. So that's at the point where if it's provincial crown land, Canada accepts administration and control of the lands. And for fee simple land, we negotiate a purchase and sale agreement where for a nominal cost, Canada purchases the land from the First Nation, usually their band corporation. So Canada has to have title to the land. So some people might not be aware of that, but the title of all reserve land rests with Her Majesty in right of Canada. So just that in terms of land tenure. So any questions about land tenure? Okay. This is what I call the meat and potatoes. So when you say how long does an ATR take, these are the pieces that make an ATR take a long time. And these are pieces where when you're choosing lands to be added to reserve, if you choose lands that have complications in any of these categories, that is what makes it take a long time. So it's not anybody, either the First Nation or Canada or whatever, dragging their heels. It's that there are issues that need to be addressed, and some of these can take a long time. And I'll be going through each of these individually, but just to give you a snapshot of the 6 major issues that we are dealing with when we're doing an addition to reserve. So I'll start with survey of the lands. The lands need to be surveyed to Canada Land Survey Record standards. So if you have fee simple lands, it may be that they've already been surveyed to a standard that would be acceptable for the CLSR, but it also may not be. And it seems like survey is a pretty straightforward one, but if you're looking at large swaths of land, this can cost a fair amount of money. So you have to make sure when you're doing your ATR, depending on the size of the lands that you're adding, that you have a budget to survey the lands. And you can get in touch with us and we can put you in touch with our NRCan surveyor who can give you the standards that you'll need. But the thing is, if you're hiring a surveyor to survey lands, because say you have provincial crown lands and you want to survey out a portion of them, you have to make sure that you hire a surveyor who's certified not just for BC surveys, but for Canada surveys, because they have to be able to know the requirements to survey them. So for example, the requirements for posts and whatnot, that you have to have physical posts at certain landmarks within the property. So some of the pieces that can be problematic is when a survey is done, they might discover, like with one ATR that this ended up taking years to resolve, is that a road had been built that encroached on the land that was being considered for addition to reserve. So there had to be, and this was a municipal road, so there had to be a negotiation with the municipality for not only for the cost of the encroachment for future use, because we're not going to ask them to move the road, but the road now encroaches, and then that's a negotiation that took years to conclude. So a survey will highlight some potential issues. And that's a thing that you have no way of knowing ahead of time whether that's going to rear its ugly head. But we're on number 1 of 6. So that's one potential problem that can arise. So we call it provincial and municipal notification. Sometimes they say it's consultation. The municipality and the province do not have a veto on an ATR, and that's very clearly stated in the policy. And it's important that the municipalities understand that. Not a lot of municipalities, and when I say municipality, when we say municipal notification, so within BC, it's a different structure than the rest of the country. So in BC, there's different types of municipalities. So there are 51 cities in BC. Then there's a district municipality. So I think like North Vancouver is a district municipality. There's the city of North Vancouver and the district municipality of North Vancouver, 2 separate entities. There's 50 of those. There's one Indian government municipality, that's Seashelt. There's one island municipality, that's Bowen Island. There's 2 mountain resort municipalities, that's Sun Peaks and Jumbo Glacier. One resort municipality, which is Whistler, 14 towns and 42 villages. So when we say municipal notification, that's from within that list. So if there's a piece of land that's outside of what we think of like town, village, or city, it's usually a regional district. And for the most part, like we're negotiating with them to see if there are any issues that we might not be aware of. So one that I'm working on this week, it's a piece of land where the edge of it is the ordinary high water mark, and there's a public wharf. So the municipality said, we want to be sure that the public can still have access to that wharf. So we had to do the research, and it turns out that there's a road that goes through the ATR that ends at the water, and that's where the road is that goes to the wharf. So we were able to send them a Google Earth map with some drawings on it and say, here's the wharf, here's the road. Yes, the public can still have access to the wharf. So it's not like they're necessarily going out of their way to just roadblock it, but they'll ask questions and then we have to answer those questions. One question that often comes up, because we're all in BC here, when I talk to the rest of Canada, they're like, what? If you know what the agricultural land reserve is, it's where a lot of land within BC was designated to be reserved for agriculture. So it's part of what's called the agricultural land reserve. There was a time when we had to request the First Nation to go to the agricultural land reserve to request that the ATR, proposed ATR lands be removed from that. We no longer do that. But there's an ATR that I'm working on now where I took them 5 years to work with the ALR to get their lands removed. So that's one hurdle that we don't have anymore, but an example of one of the pieces that can take a long time. With the province, if the land is coming from the province, they have their own due diligence that they do before it's called disposing, before they dispose of the land. So from our perspective, we don't need a letter from the province because they're transferring us the land. And if it's federal land, we don't need to ask the province because it's not provincial land anymore. So it's mostly fee simple land where we would be consulting with the province. And again, that's just in case there are any issues or concerns that we may not be aware of, looking on title or looking on the Integrated Land Resource Registry. We want, our purpose for consulting with provincial and municipal governments is for them to flag any potential issues that we may not be aware of. So that's what that comes from. So any questions about the provincial and municipal notification? Okay.
Sorry, I have a question.
Yes.
So you talked about a nation that had a road that was built through their land, and that they had to negotiate with the province or whatever for this road. What if they didn't want the road there? You know what I mean? Like, what if they already own this land and it was essentially infringed upon? Mm-hmm. What rights do they actually have to make change to that?
Yeah, so they in that case, they can negotiate. So in the case that I was speaking of, it was a municipality that's perhaps a little different because each municipality is different, but more generally, I'll speak to it from a provincial perspective. So if the province built a road through a reserve and then the First Nation is like, why did you do that? We don't want that anymore. They would need to negotiate with the province. So number one, on the loss of use of the land from the point where they built it to wherever they move it. And they would generally, they could ask the province to build another road or just close that road. And then sometimes they might look at negotiating a land exchange to say, hey, you've carved out 2 acres of land from our reserve to build this road. The road does serve the community, so we're not going to ask you to remove it, but we want you to give us other land in exchange for that, what we call a land exchange. So there could be a number of different things, but it will be a matter of negotiating with whichever entity it was that built that road and coming up with a solution.
Okay,
and that's would take a long time because the negotiations, you've got lawyers negotiating with lawyers and whatnot.
And would that work the same? You use the example of there was a nation that had land by the water or whatever, and that the city or whichever entity still wanted access through that land. Would that work the same way?
Well, in this case, they just wanted access to a public dock. And there was access to that public dock, but they can't say, oh, we want to be able to access the waterfront. It's like anywhere else. No, that waterfront is part of a private, this was fee simple land.
Mhm.
It's like, no, there's, what's the reason why you would want that public access?
Okay, so the process is essentially stalled until those negotiations are done then?
If the ATR lands, so, and that's where the process of choosing, so we're talking about addition to reserve lands as opposed to an existing reserve that has a road going through it, for example. But let's just say if you have an existing reserve with a road going through it and you want to add that road to reserve, that process is going to take a very long time. And I would say that process would need to be near its conclusion before you would apply to add those lands to reserve. So you would need to negotiate it in, say if it's the province that has the land, you would need to negotiate with the province about that road and say, we want to add that to reserve and we want the road closed. So you'd need to go through all that negotiation and have that concluded where the province is like, yes, we're going to close that road and you can add it to reserve. So that would take a long time.
Thank
And
you.
again, like I said, roads, I could give a whole presentation just on roads.
Thanks so much.
You're welcome. And in fact, you could hire a full-time officer and a full-time DOJ lawyer and you would barely scrape the surface of all the road issues just in BC. It's that bad. So we just say status unknown with a lot of roads. So just be certain when you're choosing lands to add to reserve that you've identified roads and whatnot that are part of the ATR lands. In particular, and I cannot stress this enough, if that road is going to be part of the reserve and that road provides access to fee simple land outside of the reserve, you need to negotiate an access agreement with a private landowner so they can go over the road within your reserve to get to their fee simple land. Because you cannot purchase land that's going to leave someone landlocked. And in my experience, so you have a little old couple that has a B&B just beyond your reserve, that took like 5 years to negotiate with them for them to agree to an access agreement over the ATR lands. So just be aware of that when you're choosing lands. Who might it landlock if you own that land, if there's a road that goes through it? Unless you choose to exclude the road and then have the road be a provincial road. Again, roads, fun time. Any other questions about municipal and provincial notification? Okay, I'll move on to the next issue, which is service agreements. So we won't necessarily require that you have these agreements in place unless the lands that you're adding to reserve either already has infrastructure on it that will need these, or there's a concrete plan in place for development. So service agreements like water, sewer, fire protection, waste disposal. It's interesting, we currently don't have a formal process in place, but I would say, I mean, there should be something in place for fire protection, because if lands become part of reserve, they're no longer part of the municipality. And it's usually the municipality that has fire protection. And you want to make sure you have some kind of agreement in place for who's going to do fire protection. Some First Nations have their own volunteer fire department, and that's fine. But just depending on where you're adding lands to reserve and whatnot, you just want to make sure that you've got, even if it's just bare land, it's just, you know, you have a car in there that catches fire or something. It's just something that you want to look at. The other one is hydro. Quite often, if there is development, there's two kinds of hydro infrastructure. One is transmission and one is distribution. So transmission I'll talk about in a minute, which is third-party interests, but because that's where they've got big, high-powered lines going through to provide service to other parts of the province. Distribution just means they have poles and lines to provide hydro service within the ATR lands or within an existing reserve. So if there is hydro infrastructure, you're going to have a permit to negotiate the permit before the lands are added to reserve. So any questions about service agreements? Okay. So the duty to consult, so Aboriginal consultation. So it's important, so when you apply, send in your application to Canada, and I'll go through that process at the end. One of the first things that we're going to do is send out a consultation letter to neighboring Aboriginal groups. So just from the perspective of good neighbor relations, we recommend that you speak with neighboring First Nations to let them know that you're considering adding certain lands to reserve, because if the first time they hear about you adding lands to reserve from Canada, the optics might not be that great. And it just helps smooth things over down the line. Also, if you're aware of a potential conflict, you can let us know at the beginning and we can have an idea of how that's going to go. We have had that in the past, and again, this is something that can stall the forward movement of an addition to reserve. And at this point, we used to look at, low, medium, and high risk and whatnot. We give First Nations 90 days to respond to the consultation letter. It doesn't mean that at the end of the 90 days, they've lost their voice. It just means if we don't hear from a First Nation after 90 days, we send them a letter saying we're moving ahead with this addition to reserve, but if you have problems or concerns, please let us know. We're hoping that if a First Nation does have a concern, that it would be aware of them and bring them to our attention sooner rather than later. So again, it's a fairly big piece, and obviously many of you who are First Nation members or employed by First Nations, you're on the receiving end of consultation requests, not only for ATRs, but a whole number of other pieces of business that take place for the governments that you're on the receiving end of having to respond to. So I'm sure you're aware of what this is all about. So any questions about Aboriginal consultation? Okay. Second last piece is environmental. Pretty self-evident, obviously. So we have a new policy. It's not new anymore, 2016, coming up to 5 years now, that the lands only need to be remediated to the level that the lands will be used. So if the lands will be used for commercial, they only need to be remediated to commercial level. In the past, everything had to be residential level before it was added to reserve, which is sometimes unattainable. But just do keep in mind, so when you're considering adding a piece of land, usually, I mean, you can probably be a good idea for you to get a phase 1 ESA, environmental site assessment. And when they do that phase 1, they usually do a history, so they can see there's a history of some activity that has the potential to contaminate the lands. And then you'll get an idea of what you might be up against. This is one of the big pieces that can hold up an ATR. And in fact, quite often what happens is it's known that there's some environmental issues. So a lot of time is spent on the environmental, and then they wait till that is done, and then they go to some of the other issues. And then they realize that the other issues are going to be time consuming. So if you're working on an ATR and it's got environmental issues, don't let that stop you from working through all the other issues, because they can be done simultaneously. So when you get the deck, there's a hyperlink here to the CCME, which is Canadian Council of Ministers of the Environment. And it's got the categories of contamination and what levels are acceptable. Any environmental business worth their something will know what these are, but these are the 4 levels from cleanest, which is agricultural, to residential, commercial, and industrial. So sometimes what might happen is, say you have a piece of land that had, and say you've got a piece of land that's like 50 acres and 5 acres of that were used for industrial. You can zone without having to survey it out. You can just state within your application that this zone, and you can delineate it on a map or a survey, will be zoned industrial and the rest will be residential. Then that means that when they do the environmental work, they will investigate the area that you've designated industrial and make sure that it meets federal standards for industrial, and then the rest of the land can be residential. So this is a bit technical, so I want to make sure that if there's any questions that I can answer them and that there's no confusion about that. And depending on the environmental company that you use, they should be able to help you with that. But do make sure, often in cases where you're getting land from the province, like if sometimes there's like a land exchange, or they're transferring land to you for one reason or another, when they're doing their investigation, they're doing it to their provincial standards. So if you're in discussions with any, whether it's a province, a municipality, a regional district, that they're looking at giving you lands, make sure that you let them know that everything they do, from survey to environmental, needs to be to federal standards, because then they might have to redo some of it, and that can cause delays. So just make sure that they're aware it needs to be to federal standards if it's being contemplated as an addition to reserve. And I've saved the best for last, third-party interests. This is an easy one to just let slide and say, oh, we'll deal with this at the end. Please don't do that. It can be complicated. Like, it's easy to look on title and see the encumbrances that show up on title. But there's also something in BC called the Integrated Land Resource Registry that you have to do a separate search for, and that'll show things like waterworks and easements and things like that. So as a rule, when we add lands to reserve, we want a clear title. We don't want anything on title from the province when the lands are added to reserve. Now, there might be something that was on title that's going to be replaced with an Indian Act interest. And what happens is, remember how I said previously, where when we do the Ministerial Order, the lands are transferred to Canada. And when the lands are transferred to Canada, we do discharges for all the encumbrances that are on the provincial jurisdiction, and we have replacement interests that are signed that will come into effect when the lands are added to reserve. It can be highly technical and difficult to understand how all that works in terms of that period of time between when Canada acquires the land and the minister signs it, and how do third parties get a comfort. But there's ways of making it happen. Now, the other consideration is, if your First Nations operational under FNLM, that means that you're managing your own lands. So the replacement interests will not be Indian Act interests. They're going to be land code interests under your own land code. So all that we ask is that, and it depends on who we're working with, the lawyers and everything, but we want to have an assurance that you have a replacement interest and you are responsible for negotiating and managing and everything with the replacement interest. Now, one thing that recent legislation allows is that if you want to add lands to reserve that has an existing operating business, you can now do that because, and the businesses are under a lease. So under the Indian Act, if you want to lease land, you need to designate the land. And a designation involves a vote by the membership to designate land for a certain number of years and for a certain predetermined purpose for the purpose of lease. And what a lease does is it gives exclusive use of the land to the lessee. So that's why the membership needs to vote, because they're basically removing the land from the use of the ban for the period of that lease. So what we now allow is what's called a pre-reserve designation. And I'll go over that a little bit more at the end. But pre-reserve designation means, like, say you purchase land that has an existing gas station on it, and you want to keep the gas station. So you can, but you're not sure how the membership feels about it, you can do the pre-reserve designation vote. And if the membership votes it down, then you're probably not going to add that lands to reserve. Or you'll wait till membership votes in favor before you look at adding that land to reserve. Because you would not be able to add it to reserve without a lease replacing it unless the gas station was closed and decommissioned or something like that. But third-party interests, as I mentioned earlier, it can appear to be something very simple. Oh, it's a little easement for the bed and breakfast people to go across this road. Well, they have to hire a lawyer. Their instrument might just be very simple. They have permission to go over this road. We're replacing it with a federal instrument where we have insurance requirements, liability, a whole bunch of different requirements. And, you know, they have very little incentive to replace the interest because you cannot remove the interest. They have that interest in perpetuity. So you're asking them to replace it with an interest under a different jurisdiction. So those are the things that can take a long time. So just make sure when you're considering adding lands to reserve that you're fully aware what are all the encumbrances, what are all the things that might need to be replaced. Because, and that's why I say leaving the best for last, because in my experience, spoiler, it's not the best, it's the worst. These are the things that often end up taking the longest and dragging on. And there's a tendency, I guess I would say, to deal with what we call the low-hanging fruit. Survey is easy to knock off. Environmental can take a long time, but it's easy. You know, there's this much contamination. That's what we got to do. Aboriginal consultation, most of the ATRs that I've dealt with or that I've seen, probably 99% of them don't really have too many issues when it comes to the duty to consult. Municipal, provincial, generally, you're answering questions and whatnot, maybe negotiating a few things. And so you knock off those easy ones and you leave this one for last, and then you're stuck for years negotiating these replacement interests. So my advice is to start with this, but it's tough because you have to get lawyers involved who have to look at all this stuff and really tease it out, because sometimes you can end up with like 5 pages and you have to go through that and say which of these can be removed, which of these need to be replaced. It has to be very, very clear from the beginning and start the negotiations right away for the things that need to be replaced, because that can take a long time. So just something that's important. Third-party interests. Just have that tattooed at the back of your head if you're looking at doing an ATR, because that's what'll come to bite you. So that's the end of the major, what I call meat and potatoes. These are the pieces, these are the 6 pieces. When we say how long does an ATR take, it depends on your land selection and how complex the pieces are within that land selection. Because I've heard people say it's a piece of bare land. It looks bare land to the eye, but you look at it, you know, from a legal perspective, and there's easements, there's permits, there's a whole bunch of things that you don't see on the land. So don't be deceived by thinking it's a piece of bare land. You have to get the title report. You have to get the ILRR report, Integrated Land Resources. I always forget. ILRR. It's from the province. And the problem is too that you might get a list of the instruments, but to get a copy of the instrument can take 6 months because in some cases the instrument is not scanned. It's in a filing cabinet in an office somewhere in the province. So when you're asking for documentation, that in itself can take a long time. So if you do that right from square one, you're a little bit ahead of the game. So before I move on to the 4 phases of the ATR, are there any questions about the middle piece of ATRs? Because that's a lot to take in. And I'm a visual person, but I don't like giving, it's the nature of the beast. This PowerPoint is just very text heavy, but there's a lot to consider when you're doing an ATR. So you'll have, like I said, you'll have access to download this with all the notes and everything to help you. But I'm hoping this gives you just a general sense. And if there is anything in the chat, maybe Pat, you can let me know because I'm not seeing it here. Okay, so I'll move to the 4 phases of an ATR. So again, in 2016, when we revised the policy, what had happened was a First Nation would send in a BCR and think they have an active ATR, but not a lot of work would be done. And then we just, you know, things would just fall off the edge, and then there wasn't an active ATR. So now what we have is a process that makes it clearer for everyone, you know, what's active and where it is within the process. So all of the ATRs from 2016 forward have to be initiated with an application from the First Nation. It's a fairly comprehensive application, and we ask that you, when you do an application, you do it when you're far enough along that you know that there's a commitment from the landowner that they're willing to sell the land to you or transfer it to you. You have a general idea about the environmental condition, some of the third-party interests, things like that, before you apply. Because otherwise, if you apply, because we had one recently where they hadn't even spoken to the province about acquiring the land, and it's like, we needed to be a bit further along than that in order to move things forward, because it wouldn't make it to the end of phase 2. And so when people talk about how long does an ATR take, if there's an application made but not a lot of work done, it can seem, so 15 years can pass and it seems like that's a long time. But if you wait till you've got a lot of the pieces in place before you do the application, then things are ready to move forward. So the initiation, you send the application and you're working with one of our officers who goes through the application with you to let you know what's missing, or might say, not quite ready yet, make sure that all the documentation is ready. And then we send a formal acknowledgement that we've received your completed application. Phase 2 is ISC. We do the assessment and review of the application. So that's where we go through it a bit more with a fine-tooth comb and make sure that you've done due diligence on a lot of areas. That's the point where we send notification letters to the province, to the municipality, and we start the process of the duty to consult. So there's no hard and fast timeline, but it's generally done within definitely less than a year, maybe like 3 to 6 months or so, that we can look at issuing the letter of support. The letter of support is signed by the Regional Director General, who right now, Catherine Lapa has been promoted to a different position. So Bill Guerin is the acting Regional Director General. So we'll sign the letter of support. And that's basically so that you know that the department has accepted your ATR application and that it will be moving forward within the department. What the letter of support has is an appendix, a page that lists everything that you need to do for the proposal to be submitted to the minister. And that's those 6 items that I listed earlier. It'll state you've completed the survey, but it will need for it to be registered. The lands will need to be remediated to be acceptable. All third-party interests will have to be addressed, that kind of thing. So that's the letter of support. So those 2 pieces can happen fairly quickly. But number 3, that's the section that I just finished, what I call the meat and potatoes. That's where really the bulk of the work is done. And it's done in cooperation between the First Nation and Canada. So you have to have the resources and whatnot to move the work forward, to keep on top of things, and to ask the questions that need to be asked to make sure that you've got your companies doing the work that needs to be done, whether it's the environmental or the survey or whatnot. But this is where it takes the most time. And the onus, I would say, for you to keep in touch with the officer that's working on your addition to reserve, at the very least every 6 months, but hopefully more often than that, maybe even once a month, just to keep in touch and to make sure that it's moving forward. That having been said, currently, and I'll say generally, it's not black and white, because I know someone said they have multiple ATRs. We like to accept one ATR at a time, both for our own capacity, because we have close to 80 ATRs that are active currently, and I think 4 officers, so you do the math. It's a lot of work. And also within your First Nation, if you're the one who's doing the ATRs, you may be doing other work as well, and it's a lot of work for you to keep on top of, to keep the ATR moving forward. So it's just something to keep in mind. If you have more than one addition to reserve that you're contemplating, then between chief and council, membership, or whoever is going to make that decision, you'll want to prioritize them and decide which one's the most important to the community that you want to get done, and go from there. And while you're doing that one that's been submitted, you can do some of the work on the others based on what you know needs to get done from that phase 3, which is section 4 of this PowerPoint. You can work on some of that. For any other ATRs that you're considering, you can start the environmental work, and knowing what it's going to need to be, you can do that work even if the ATR is not in the hopper, as it were. You can get that work done through remediation. You can look at third-party interests, you can identify them, you can start negotiating with third-party interest holders and say, we're looking at adding these lands to reserve, we're going to have to replace it. You can start negotiating. So just something to consider in terms of, if you have more than one ATR, how to prioritize them. And the last piece is ISC that does. So when all the pieces have been completed, then we draft the ministerial order and the briefing material. And at that point, it's out of your hands, and we submit it to the minister for signature. And that was a fairly recent change. It used to be an order in council, and then order in council meant that it had to be, had to go to Treasury Board. So it needed, let's just say, a lot more work, and it was a lot more complex. Ministerial order is much simpler for it to happen. However, once it's at that stage, we cannot give you feedback about, oh, it's left the region, oh, it's been signed by this person, it's been signed here. We can't, just by the nature of the business, we can't give you updates. We can just say it's been submitted, and we'll let you know when it's approved. So you have to respect that we can't give you updates on the internal processes on that, just for a variety of legal reasons. So then other considerations. I mean, I just went on this, explained this here about the prioritization. So pre-reserve designation, again, I think what this does is unlocks a lot of potential ECDev opportunities for First Nations, because we haven't been able to do this. I know I had a First Nation that wanted to add lands to reserve years ago because they had a motel. So they were running the motel, but it couldn't be added to reserve because that's a lease. So now with pre-reserve designation, they can look at doing a pre-reserve designation, and then if the membership votes in favor, they can add that land to reserve with an operating motel on that land. And again, just so that people are clear, if you're operational under FNLM, you don't need a designation. So you don't need a pre-reserve designation. So you can just, that opportunity was available for FNLM operational First Nations.
Theresa, would you like for me to read any of the questions out for you? I'm with Can Do. I can help out if you feel like you can't
Sure. Let
quite
me
see. I just want to make sure if any of the, if there's a couple minutes before you move on, if there are a couple of these questions get answered. One of them is, let's see, from Alvin. I don't know, Alvin, if you had your questions answered already, but he did ask if one of the final stages still a recommendation from region to the ATR committee at Ottawa. He says the challenges at the time to complete the ATR process will often stale date the environmental assessments.
correct. That's a very good question. So, so the environmental, it's trying to find that balance, because third-party interests are a piece that can slow down an ATR. So you want to have an idea of where things are at with the third-party interests. The way that the process works is when it comes to the point where we're submitting the ATR for ministerial approval, the environmental site assessment can't be more than 5 years old. But just if it is more than 5 years old, it's like an update that needs to happen. So it depends. So if you've got like an active business that could have potentially contaminated the lands from 5 years ago till now, that might be more difficult than if you got like on the ground a piece of bare land that nothing's been done. Then usually you can hire the consultant to do a quick review, and they can make a statement, no activity has been done in the last 5 years, and the land is still suitable for addition to reserve. But that is a consideration. There is currently the requirement that the environmental site assessment be no more than 5 years old. So it's something to keep in mind, to look at funding sources to do an updated ESA if you're finding yourself coming close to that 5 year mark. So I hope that answers the question. So I do see the questions now. So Alvin has the question about surveying out the access interest and have the remainder set apart as reserve. Yes, that certainly simplifies it so that the road you're not working on. But then the question is, do you have someone who will take responsibility for the road? So if it's a provincial road, you know, for the most part, those usually don't get added to reserve. But it's usually if it's a private road. So you might be better off, but then you have to make sure, like, is the municipality going to take care of that road? Like who will maintain it? But surveying it out certainly simplifies the issue of negotiating replacement interests for fee simple owners outside the ATR lands. So the 12 years working to resolve an interest, I mean, we can have a discussion on that offline. Conservation development area. And that's the thing, if they didn't have the money for legal to review the documents that you're resolving an interest, that's where you're caught between a rock and a hard place. And there's currently no money at ISC to help third-party interest holders feel motivated, like, here, we'll cover part of your legal costs or something of that nature. We don't have anything like that currently. And this is a national problem. And we don't have an answer currently. So these are specifically the kinds of things that where you end up with, you know, decades long ATRs. So in terms of municipal zoning, just saying, so when you're adding lands to reserve and for an urban reserve, it's tricky. When lands are added to reserve, they are outside the municipal jurisdiction. So municipal laws don't apply anymore. However, generally when you're adding lands urban reserve, you might do, like, say, bylaw harmonization or some negotiations or whatnot to, you know, to work side by side. But I don't know, for anybody who lives in Vancouver and it's not that old, I don't think it's that old. Squamish First Nation has a reserve underneath the north end of the Lionsgate Bridge and the south end of the Burrard Bridge, and they wanted to build billboards. Well, the municipal regulations are you can't have billboards this close to a bridge or this close to it. And then there was such an uproar that they said people are going to be crashing, it's a distraction. And the federal review was, no, it's going to be fine. And it's fine. But that was an example of a First Nation. These were reserves that had existed for a while of conflict between municipal bylaws and federal. So from the perspective of adding lands to reserve, it's up to the First Nation to negotiate whatever they want to negotiate. We don't take part in that. We leave that for you to negotiate what you want to negotiate. And keep in mind, like I said, the municipality doesn't have a veto. So you do your best to work with them and harmonize with them. But at the end of the day, they can't just say no. However, if like there's a situation where the municipality has infrastructure that runs underneath the ATR lands, so there needs to be a permit negotiated with the city for that permit. So the city could just play hardball and say, we're not going to negotiate that. So that land cannot be added to reserve until we have an instrument in place. So just keep that in mind as well. And that infrastructure currently has no provincial, it's not a provincial interest, it was a private interest between the previous landowner. So you have to be aware of everything that's there. So is the final stage, so the final stage from the First Nations perspective is just making sure that all those 6 criteria are met. Then it's an internal process that ISC, I mean, our ISC lawyer has to agree that all the parts of the ATR have been met, the requirements have been met. We have our own internal policy, but they look at it from the legal perspective. So if all the legal pieces aren't in place, DOJ will not recommend it. Once they have, then it goes to internal BC region approvals, and then it goes to HQ approvals. Also, you may or may not be aware, when the departments split, so additions to reserve in the regions are under ISC, but the land is held by CERNAC. So it's Minister Bennett that signs the Ministerial Order. So just to put that into a little bit of perspective. And yes, all ATRs are important to the community for sure. Someone said, Melissa said, provincial sites charge for plans and you don't have access. Usually lawyers will be able to get that access. I mean, through the LTO, you can pay, anybody can get an LTO account and you can pay the money to get the plan or the title search and that kind of thing. So again, that's where it's like, from your perspective, you will need legal counsel to help with parts of the ATR. The challenge is finding where you'll need them and, just try to reduce your costs, because they're not cheap. But certainly if you have fee simple land, there's going to have to be conveyancing to Canada. And if there's any third party interests, you're going to want a lawyer to review the documentation to make sure that you're protected. So there was a question about the Métis people. Currently in BC, we do not consult with the Métis, just based on the history and whatnot of the lands that were given to the Métis. They were not given land in BC. But if we have any information to the contrary, that can certainly change. But for now, that we do not send consultation letters to the Métis. The service standard to evaluate when other First Nations express an interest. So that is that if another First Nation says, we object to this addition to reserve? That was from Alvin. Yes. So when a First Nation says we object, we want to, the burden on them is to provide proof. So we say, if they say we have title to this land or we have rights to this land, so we want to know what's like, we want documentation that shows why. And they might have comments and whatnot, but again, they have to show that, you know, what, like a clear indication of why they should have the right to that land over another First Nation. The only one that I'm familiar with was where the First Nation with the ATR knew that they were choosing land in the territory of another First Nation. At the end of the day, I think they provided alternate land to them as compensation for having taken land within their territory. We've had a situation where First Nation had land that was extremely remote. They had stopped schools there that was just so nobody could really even live on their reserves. So they had moved to near a municipality that was part of another First Nations territory, but negotiated with them that allowed them to add lands to reserve so that they could reestablish a new community that was more viable. But it's a lot of discussions and a lot of communication. So I think I've answered most of the questions. If I've missed something, just let me know because there's a lot here.
There's just one more, I think, on the very last here from Owen.
Okay. So bylaw harmonization, is there anybody who can work with bylaw harmonization in the development and implementation of the bylaws and schedules associated with our MSA? MSA is a municipal service agreement on an ATR parcel. So generally that's something that we leave to the First Nation to negotiate. I do have a separate deck where I've presented to a municipality, and there's quite a few. If you want to contact me, Owen, after, I can send that to you. It's got some links to the BC Federation of Municipalities, I think it is. So there's templates and whatnot on that, and that can help. It's difficult because there's not a lot of background for municipalities that have done this kind of thing. So it's a tough one, and we don't really have a lot of we don't have any experience with doing this kind of thing. So it's a tough one. So from Melissa, we will be doing designation vote this year. So yeah, pre-designation. Definitely, when I heard about that, recognizing the potential economic development that unlocks is quite important. And just for anybody who's curious, BC has been doing designations throughout the pandemic. So don't let that stop you from, because I think they have to have an information meeting. I think they do that by Zoom. They mail out ballots to on and off reserve, and they have an ISC staff goes to, I think in one case, they just sat in their car so that people could come and vote in person. That was a bit more of a remote community, but we are still conducting designation votes. And so that's something to consider. But the pre-designation vote would only happen after you've submitted an ATR application. So just consider that. So just let me, so I'm just gonna share screen again. And this is an easy one for you to remember, the URL, aandc.gc.ca/ATR. So that has a whole whack of documents, including the new policy and application, information about the new policy that came into effect, a new legislation in 2019 called ALERCA, the Addition of Lands to Reserve and Reserve Creation Act. That's the one that allows for pre-reserve designation and so on. And these are the documents. this is a Dropbox, and this contains, again, I'm not going to go through everything, but everything you wanted to know about ATRs and more, including this slideshow. So I'll give you a minute to write that down. And then NELMA gives workshops, and they give a full 3-day workshop to walk you through the whole process. But if you don't have a chance to take that, just contact us and we can help walk you through the process of applying. And membership in BCOM is a branch of NELMA, $300 per year per First Nation, and it includes travel sponsorship for up to $2,500 when the pandemic is over per person per First Nation. And this is my contact information. And if you have general questions about ATRs, this is our general email. So if there's other questions, I'm still here till 10:30. But thank you for your patience during this. I know it's a heck of a lot of information to take in 75 minutes. But again, you know, we're here to help you. We're here to answer your questions. It's just to give you an idea of what an ATR is involved, what's involved in an ATR, and to help your First Nation think about what you might want to look at adding to reserve. But I hope it's helped you with understanding considerations around what kinds of land you're selecting. Make sure if someone is giving you land that it's clean, doesn't have third-party, because I have had that where a municipality gave land to a First Nation, and it's really complicated. It's decades long, and it's you know, the municipality is sort of helping as best they can, but it's a bit of a slog. So just be aware of that. It's nice to get land, but it can take a long time to get it in a condition that's ready to be added to reserve.
Well, thank you so much, Theresa. Appreciate all the great information. Just want to let everyone know that the slides as well as the recording of your presentation will be available on the HOVA app. So you can go back in and access. And I don't know, Theresa, if you're going to be around for any more of the rest of the BC links, but I know that people can arrange little meetups with you at other times as well. So if you're available.
Feel free to contact me directly. There's a national ATR forum going on right now, so I have to go back. We're talking about national issues, so I'll be leaving this at 10:30 and going back to deal with that. But certainly, you can contact me directly. I'd be happy to answer any questions you might have, whether it's via a one-on-one Zoom call or by phone, or even if you have email questions. I'm always happy to answer questions to help prevent problems down the line.
Yeah.
Better to ask questions now than have a headache later, for sure.
Right, then ask for forgiveness later.
Something like that.
All right, thank you so much. Then everyone, just make sure that you go into the surveys as well on the HOVA app, where you can give some feedback for any of the presentations that you've been enjoying this last couple of days. And we'll have a little health break right now. And then, so we do have a bit of time if you want to stay on for a few minutes and talk, and you can probably be able to unmute yourself and just to say hello and to answer a question. And anybody else, you just go back out into the agenda to the main room, and then you should be able to enjoy the sessions afterwards. All right. Thank you again, Theresa.
Thank you very much. I'm here till 10:30, so I'll stick around.
Awesome, thanks.
Enjoy the rest of your day, everybody, and the rest of Links to Learning, which my colleagues have organized. So hope you enjoy.
I think Pat said he'll have to stop the meeting in a minute here. So if anybody doesn't have any more questions, then maybe we'll get on to the next sessions anyway.
Okay.
I think everyone's gone a little quiet now. So probably that means you did a good job.
Okay.
All right.
Sounds good. Thank you very much, everybody. Take care. Bye-bye.
Hi, Theresa.
Yes,
I had a question.
sure.
So it's not out of BC, but like I still wanted to ask you.
Mhm.
So I come from Sioux Valley, which is in Manitoba, and it's a self-governing nation now.
Mhm.
And in our self-governance agreement, we have that any land purchased by Sioux Valley becomes automatically federal land. But we have a parcel of land that we purchased and is under a company, like a corporation. Sorry, I couldn't remember the word.
A band
Um,
corporation?
yes,
Okay.
that was previously purchased about 20 some odd years ago.
Mm.
So it doesn't fall under the process to make it like an ATR. Is there a way that like we could sell it from one corporation to another corporation?
I'd get in touch with I'll find out who you can get in touch with in Manitoba, because you want to make sure that if you do that, that's going to be acceptable to them. And they're probably going to have to talk to their DOJ, Department of Justice lawyer and whatnot.
Okay.
Because when you get into the legal technicalities of an agreement, you might think that that's a way of circumventing it. It might work. It sounds like it on the surface, but I'd sure hate to say, sure, that go for it, and then
Yeah, and then it'd be
2
all
years
tied
down the
up.
line, they're like, yeah, no, you owned it, and now you've just, played a game, and you can't. That's not going to work. But
Yeah,
does the agreement give any limit to the number of acres, or it's just any land that you purchase?
any land that's purchased.
Oh, that's interesting. So
And
it becomes
it's
federal land, but does it become, or do you have reserves, or is it just with governing? Is it just your own land? It's not.
just with the self-governing.
Okay.
Yeah. I'm trying
Hmm.
as far as I know, like don't quote me, but as far as I know, that's how it's set up.
Interesting.
Yeah. Because we had another parcel of land that we got changed to reserve land very quickly. It was actually kind of surprising how quickly it won bout. And so this is another piece that we were looking at, but we've owned it for 20 years. It was a former residential school.
Oh, wow.
Yeah, so that's why it was offered for an Indigenous nation to take care of. So now we're just trying to figure out what to do with it. So, and
Mhm.
it's surrounded by provincial land.
Like
So
Crown.
it's a very small strip, like a very small strip of land, and
Mhm.
it's surrounded by provincial land. So
Do you want to give me your email address, and I can find out who can get in touch with you to?
yeah, that would be great.
Sure.
Just in the chat, or
Yeah, then it's easier for me to copy paste, if that's okay.
that's fine. Perfect, thank you.
Excellent. And that's Sioux Valley First Nation, right?
Yes.
What part of Manitoba is that?
It is 20 minutes west of Brandon, Manitoba, and 10 minutes north of the #1 highway.
Okay. Yeah, I'll find out who you can get in touch with and send that to you. Sioux Valley
Perfect.
Dakota Nation. Okay.
Thank you so much. That was a lot of really great information.
Oh, you're welcome. My pleasure.
Have a good day.
You too. Well, thank you, everybody else. And unless there's a quick question, because I think Pat has to, he needs his health.
Still have, we can go till 10:30. That's fine.
Anybody else have any questions, concerns? Looks like we're good, I think. Thank you, everyone. Thank you very much, Pat. And
Thank you, Theresa.
have a nice health break, and enjoy the rest of the work of the links to learning. Take care.